Ladies and gentlemen, good afternoon. I have a pleasure to introduce you Professor Todd Berger from Syracuse College of Law. Syracuse College of Law and our faculty are in very close cooperation on the basis of the agreement signed last year. And this is why we have an opportunity to invite such a great guest. Professor is staying here for 2 weeks. He delivers lecture, survey of criminal procedure, and today we have a pleasure to hear his speech on some aspects of American procedure in criminal matters. So, Professor, the floor is yours. Thank you.
So, thank you very much, Dr. Kusak. I'd like to thank Dr. Martina Kusak for putting this presentation together, and also your Vice Dean, Dr. Thomas Naborek, for helping to put this presentation together as well. So thank you very much. It's great to be here, and I'd like to thank all of you for attending. The purpose of the presentation today is to serve as a step-by-step guide through what the American criminal justice system will look like. From the moment that police begin to investigate a crime through to the final resolution of the case after sentencing and through the American appellate process. So obviously this is what I would describe as sort of a thumbnail sketch of that process. Any one of these issues you can dig into much deeper, and there's 200 years of constitutional history on some of these issues, but this is just intended to sort of serve as a primer on how a criminal case moves through the American criminal justice system from really the beginning to the end. So I'm interested in hearing from any of you who happen to have any questions or comments on any aspect of what you hear today. And there will be certain aspects of what I talk about that have very clear analogies to the way things that might work in Poland or the European Union in general. And there may be some things that are certainly unique to the American system of criminal justice. So I'm interested in your questions and hearing your thoughts. So to begin, American criminal procedure really has two distinct components to it. It has an investigative component, investigative criminal procedure, and an adjudicative component to it as well. So the investigative criminal procedure largely focuses on how we investigate crime. What happens from the moment a crime is committed, as police begin to investigate it, gather evidence, and make the decision to charge someone with a criminal offense. At that point, once the charging process is completed, or not the charging process is completed, but once police have decided to charge someone with an offense, the investigative components of criminal procedure transition into what we call adjudicative criminal procedure, which is essentially the right to a fair trial. Then once the person is charged, we begin to focus on how do we fairly resolve this case. In that sense, investigative criminal procedure largely focuses on police and their role in investigating crime, and adjudicative criminal procedure largely focuses on the lawyers and the courts and their role in ensuring a fair resolution to the case itself. Investigative criminal procedure largely is comprised of the Fourth and Fifth Amendments to the United States Constitution. And adjudicative criminal procedure is comprised of the Fifth, Sixth, and Eighth Amendments of the United States Constitution. So there's some overlap between the amendments that comprise both areas of criminal procedure. But you'll see certain amendments like the Eighth Amendment, which deals with cruel and unusual punishment, are primarily concentrated in one area. And the Fourth Amendment, which deals with unreasonable search and seizures, is primarily concentrated in another. So first thing I want to talk about in that regard is the most important sources of criminal procedure law in the United States. So the primary source of criminal procedure law, or the most important source, I should say, is the United States Constitution. So in the United States, what's in the federal Constitution is considered the law of the land. So it creates sort of the floor, as we would say, for what the rules governing criminal procedure are, both in the investigative and adjudicative context. Obviously, there's 50 states and some territories. States are free to increase rights that criminal defendants have over and above what you may see in the federal Constitution, but states cannot go below what the rights that are provided for in the federal Constitution. So for that reason, we call the federal Constitution the floor of criminal procedure. That's not meant in a mean way, right? That's just meant to say that this is the basic rights that every criminal defendant must be afforded, although states can provide more. And in that sense, the federal Constitution really forms the closest thing that the United States has to a national code of criminal procedure. Things may operate differently at the state level in certain respects, but again, they at least have to be in a way that's consistent with the federal Constitution. The second most important source of criminal procedure in the United States are state constitutions. So obviously you have the federal Constitution, and then each state tends to have its own constitution. And as I said, states can provide greater rights than what's provided for in the federal Constitution, but they can't go below that. So this is an example of the state constitution of Hawaii. So Miranda Rights, which we'll talk about briefly, and which you may very well be familiar with from TV and popular culture and American movies. Miranda Rights have to be read to suspects before they're interrogated. If they're not read, then the statement can't come in to evidence. It's called what's suppressed. The United States Supreme Court, it said in this case, Harris, that while the statement may be out, if you're not given Miranda rights, if the defendant were to take the stand and were to testify in a way that would be inconsistent with their statement that had been otherwise inadmissible, that statement can come in for the purposes of impeachment, right? Showing that, well, your testimony here today isn't truthful because at one point you had said something different. However, in Hawaii, the Supreme Court of Hawaii interpreted their own constitution as saying, well, allowing unmirandized statements for impeachment purposes in the state of Hawaii would violate our own constitution. So as you can see, there's the federal floor, right, that you have to be Mirandized. Hawaii has to respect that, but then Hawaii provides greater rights to criminal defendants under its own state constitution that is necessary under the federal Constitution. Some states largely mirror what the interpretation of the federal Constitution, but some states also provide greater rights as well. Third, you have statutory regulations that regulate different aspects of criminal procedure. So the United States Congress has different statutes that it passes that regulate the investigation and adjudication of crime, as do state legislatures. Now, these codes of criminal procedure, again, can provide more rights than what you have under the federal Constitution, but they can't provide less. Some of these codes of criminal procedure, these statutes, they just codify constitutional rules. They basically say, well, if the Supreme Court said that in a statement, in a case, we'll just turn that into a particular statute so that it's clear for the lawyers what the rules are. Oftentimes, what they will do is address purely technical matters. So you have an example here. There's a federal rule of criminal procedure that has nothing to do with anything that's constitutional in scope. It just addresses recording requirements during preliminary hearings in federal court. It's a very technical matter. But other times you will have statutory enactment that extends to criminal defendants greater rights than what they would be provided for under the federal Constitution. And that's another way in which the legislature of a given state can say, okay, a defendant may not be entitled to this right under the Fourth Amendment, for example, but we're going to create a statute that extends a particular protection to a defendant they may not otherwise have. And lastly, this is sort of a discrete area of American constitutional law, but courts have supervisory powers, and they can also use those supervisory powers to regulate criminal procedure. So when the framers of the Constitution created the Supreme Court, they didn't have time to sit around and create a whole bunch of different rules for how the Supreme Court was supposed to work, right? They were sort of focused on much larger issues. And the same is true for people who create the equivalent of the state's court of last resort, right? The United States Supreme Court on the state level. So what courts have done is courts have said that inherent in the power that they were inherent in the creation of these courts, I should say, is the power to supervise the courts under them. And that allows the United States Supreme Court and these state high courts to create rules of procedure that would otherwise regulate kind of how things work. So they could be very technical things. For example, they could basically say, Congress never, the framers of the Constitution never said how many days you had to appeal a verdict. Right? So the United States Supreme Court could say, for example, you have 30 days to appeal a verdict. In creating the United States Supreme Court, implicit in the creation was the power to regulate the types of things that are necessary for the court to function. But they can also go a step further, and they can, for example, extend rights to criminal defendants using supervisory power that might not be provided for under the Constitution. So here's an example. The United States Constitution says that, as it's been interpreted by the Supreme Court, says that there are certain things that criminal defendants must be told when they plead guilty. But what happens if you're not told one of those things? Well, Congress went ahead, this is kind of a combination of it. Congress went ahead and they created Federal Rule of Criminal Procedure 11. And that says, okay, in addition to the things that you have to tell criminal defendants under the Constitution, you also have to tell them a whole bunch of other things, right? And then the United States Supreme Court said, well, if you don't comply with Federal Rule of Criminal Procedure 11, if you're the judge and you don't say the things that you're supposed to say, what's the remedy? And the court used its supervisory power to say that defendants could basically withdraw their guilty plea and could plead guilty all over again, right? They could start the procedure all over again if they weren't told these things under this particular rule. There's no case that says that, but the court had said, inherent in our supervisory powers, inherent in the creation of this court is the right to create rules such as that. The one caveat to it is that courts have supervisory powers so long as Congress or the state legislature doesn't act to the contrary and essentially say, we don't think that that should be the rule. So they have supervisory powers so long as, right, there's not a congressional or state action which would say, no, this is how it's going to work. This is going to work in a way that's consistent with what we think, not what the court wants to do. All right, so recognizing that those are the primary sources of American criminal procedure, we're going to turn to the steps that an American criminal case will go through. Now, I've broken this down into an 11-step process, although there are various sub-steps within the 11 steps, so hopefully we can make this, we'll go through it and hopefully you'll find this interesting. So are there any questions before I go on? Anyone have any questions about anything we've talked about in terms of sources of criminal procedure regulation? Okay. All right, so the first thing we're going to do is address the investigatory stage, right? How exactly is crime investigated in the United States? It's probably very similar to how it's investigated in most places in the world. So step one, how an investigation begins. So one way it could begin is, right, this is not surprising, this would work this way any place, right? That the police officer's out on the street and they just literally see a crime, right? So, of course, the police officer, once they've witnessed a crime, begins their investigation of the crime and their ultimate arrest. It could be everything as simple as a robbery or a purse snatching the police officer sees on the street, or it could be something more elaborate where police will go and they'll set up surveillance and they'll watch sort of complicated drug transactions that take place on the street somewhere. But either way, the police officer will be standing in a place that they're lawfully allowed to stand and they will observe criminal wrongdoing. Another way that crime is investigated is that it's reported to them by law enforcement. So I'm sure there's a Polish equivalent to this, but in the United States we have our 911 system, which is basically if you want to report a crime to the police, you call 911. It's usually for emergency situations, although I think people use it for all different kinds of purposes, right? But someone is out on the street and they're selling drugs, or you think someone's out on the street and they have a firearm they're not supposed to have, people will call 911 and report the crime and the police will go and investigate it. Another way that crime is investigated is the police use informants. And when they have an informant, the informant will go to the police and say, oh, there's this person selling drugs, and the police will begin an investigation based on the informant's tip. And another way the police get informed of crimes is there's sort of a more formal criminal complaint that gets filed, either by a person or a company, right? So someone might go down to the police station and they might say, my neighbor is, selling illegal DVDs or something from their house, right? And then says they're very concerned about that. And then the police, they'll file a formal complaint and the police will go and begin to investigate that. All right, so now we turn to step two. Once the police receive this information, how do they go about investigating the crime itself? So once law enforcement begins to investigation of the crime, they have sort of numerous techniques at their disposal to investigate the crime. However, the way in which they investigate the crime is limited by certain sort of constitutional or statutory constraints that we'll talk about, right? They just can't go and do everything that they want to do, right, to investigate the crime. They have to comply with certain rules. So one of the primary restrictions on police in terms of how they investigate crime happens to relate to the Fourth Amendment. So this is the text of the Fourth Amendment. But the Fourth Amendment essentially says that the police are prohibited from engaging in unreasonable searches and seizures, which usually require, but not always require, probable cause and a warrant before police conduct a search or seizure. So, again, police may simply observe criminal wrongdoing in a place they're lawfully allowed to be, right? They're sitting there, they observe a drug sale. There's no constitutional issues that end up being implicated. However, let's say the police get information, right, that a crime has occurred. They may wish to investigate that matter further, and in order to do that, they may have to go up and they may have to actually stop a person, right, and conduct a further investigation. So under the Fourth Amendment, before police stop a person to conduct a brief investigation into the crime, they have to have what's called reasonable suspicion that a crime occurred. Right? So it's more than a hunch, but they don't have to know for sure. But they have to be able to have reasonable suspicion in order to stop that person. However, for a seizure that goes on for a longer period of time than just kind of a brief detention, they're going to need probable cause to be able to actually stop and investigate further. If police believe that somebody happens to be armed and dangerous, they need to point to specific and articulable facts which give rise to a reasonable suspicion to believe they're armed. And then police can conduct a pat-down, right? And they can, in the course of the pat-down, they can discover evidence of either a weapon, or they can discover evidence that's apparent to them that it's contraband. For example, they pat someone down, they feel drugs. That would be an example of kind of how a pat-down situation would work. However, if police want to go further, let's say police want to search someone's bag or police want to reach into someone's pockets, at that point, police are going to need probable cause, right, to believe that, which is more than reasonable suspicion. It's not just a suspicion, it's a lot further, right? And they're going to need probable cause to conduct a more intrusive search of the person or their property. Another way that police, I will also say this, police may need a search warrant in certain instances as well. So there are a whole bunch of different exceptions to when police need a warrant. Police generally need probable cause to conduct a full-scale search. Sometimes they need a warrant. Sometimes there are exceptions to the warrant requirement, but they'll have to go and get a warrant. Another way that police can conduct an investigation, which we will talk about in a little bit later, is we have a grand jury process, right? This is very unique to the United States. Most of the Western world has gotten rid of grand juries. The grand jury in the United States serves two functions. It serves an investigative function as well as a screening function for cases. But the grand jury can actually, which is convened by the prosecutor, and the prosecutor advises the grand jury can issue subpoenas for certain types of evidence. So if the grand jury is investigating someone for fraudulent business practices, for example, they can issue a subpoena for the person's business records. Now, people have a right against self-incrimination, so people don't have to testify before a grand jury and give evidence that will incriminate them. But people may nevertheless have to turn over certain types of evidence. Your right against self-incrimination attaches to what we call testimonial evidence, which is essentially communicative evidence, but doesn't necessarily attach to physical evidence. So you may have to turn over things like documents or other kinds of physical evidence that you have. And grand jury process is a very powerful tool that police have it and law enforcement has at their disposal to investigate crime. Now, of course, police may want to interrogate someone, right? So police may want to ask someone a bunch of questions. If the police have briefly detained someone on the street and they have reasonable suspicion, police can generally go ahead within a limited period of time and ask people questions. However, if the police attempt to put someone in custody, and there's a very technical definition of custody, but it's certainly more than a brief detention, police are required to read someone their Miranda rights, which you of course have seen from TV, and they're required to do that, and if they don't, again, the statement can be suppressed. If a person has actually been formally charged, there's the Sixth Amendment of the United States Constitution, which gives you the right to a lawyer. And the United States Supreme Court has said that once a person is formally charged, the Sixth Amendment right to counsel sort of kicks in whenever police attempt to deliberately elicit information from a defendant. So they've arrested the defendant, they want to elicit more information from the defendant, then that person has to have their lawyer present before police are able to do that. But that's sort of after the investigative stage, right? That is after the person has been charged, but that is a limit on interrogation practice. And any statement that a person gives, right, before or after they're arrested, under the Fifth Amendment Due Process Clause of the United States Constitution, which says a person cannot be deprived of life or liberty without due process of law. A basic way to understand that, because what does that mean? A basic way to understand that is its basic fairness. That doctrine of basic fairness says that police in interrogating someone can't coerce statements from them with such a degree of pressure that the court would conclude the statement wasn't voluntarily given. Now, again, there's a ton of cases on that, and when exactly a statement becomes coerced is very technical, but nevertheless, right, police are sort of bound in interrogation law by the Fifth Amendment Due Process Clause. You can put pressure on someone, but you can't put so much pressure on them that the court would conclude that the statement became involuntary. So this is an example of Miranda warning. So what happened after the case was handed down is a very famous case, as you know, in American criminal procedure, and the different police departments provided these warnings to their police officers, and you're supposed to, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. During questioning, if you cannot afford one will be appointed for you, right? And most people probably know that. An interesting kind of aspect of this particular case is the defendant in the case, Ernesto Miranda. His case went up to the Supreme Court. His confession was thrown out, but he was allowed to be retried without his confession. The police found another witness. Miranda was retried, and he was actually convicted, and he was sentenced, and he did time in jail. After he did time in jail, he was released from custody. Miranda was kind of a tough guy, didn't really, have much of a sort of a legitimate employment history, and he would go around and he would sign Miranda cards. As you can see, his signature is at the bottom, right? So he would sign Miranda cards and sell them. He was eventually stabbed to death after a fight in a pool hall in Phoenix, Arizona, over something like $3 or something like that, right? Some very minor amount. The individuals who stabbed him were arrested, and after they were arrested, do you know what happened to them? Anyway. They were read their Miranda rights. That's exactly right. They didn't make a statement, and they were released because the police didn't have enough evidence, and they eventually just kind of fled and were never found again. So that's kind of the interesting story of Ernesto Miranda, one of the most famous cases in American history. All right. Police may also wish to conduct identification procedures. So someone may call 911 and say, give a description of someone and say, this person robbed me. The police may drive around, the police may find a person who matches that description, and then they want to end up having that person identified. So there are constitutional limits on what the police may do as a part of identifying someone. Under the Fifth Amendment's Due Process Clause, which remember is about basic fairness, police cannot conduct investigative identification procedures that are unduly suggestive, right? There are limits on what police can do in that context. And after you've been indicted, after you've been charged, if the police want there to be an investigation and an identification, they need to have your lawyer present. So identification procedures are regulated by the Fifth Amendment's right to fairness, the Due Process Clause, and also by the Sixth Amendment's right to counsel. You may see up on the screen there's something there about the 14th Amendment. The 14th Amendment has a due process clause as well as the 5th Amendment. The due process clause in both the 5th and 14th Amendments basically says the same thing. The only difference is that the 5th Amendment's due process clause regulates the power of the federal government, and the 14th Amendment's due process clause regulates the power of the states. That's pretty much what I just said. All right. So now we have, the police, we know how they get their information. Maybe they're approached on the street, they have an informant, they get a 911 call, they conduct their investigation. It may involve a search or a seizure, right? Patting someone down, getting a warrant, searching their house, uncovering evidence, whatever it may be. The police decide, maybe they conduct some interrogation, maybe they have an identification procedure, whatever it is, the police decide, all right, this is our person, right? We're going to charge them with a crime. At that point, we then move from the investigative stage, where we focus on the actions of the police, into the adjudicatory stage, where we focus on the lawyers and the judges, and we attempt to see whether or not there's a fair trial that's taken place. So when you think about these two phases of American criminal procedure, there are many different values that the American criminal justice process attempts to advance. Everything from lay participation to the protections of victims' rights. But the overarching sort of value that the American criminal justice system attempts to enshrine, in the words of the Supreme Court, is to search for the truth. Essentially, we want to be able to uncover wrongdoing. That's an important sort of function of any organized government and a civilized society, right? Is that people are protected from crime. And so we want the government to be able to find the truth. In the investigative stage of the criminal procedure, while police are restrained in certain things that they can do, it's primarily designed with uncovering wrongdoing, because police have, within certain parameters, the ability to conduct investigation and undercover evidence of a crime. The adjudicatory stage of criminal procedure, at that point, we're still concerned with the discovery of the truth, but what we are concerned about is making sure that the verdict is reliable, right, and that we're not convicting innocent people. And so one of the things you'll see about the adjudicatory stage, as it sort of focuses on the right to a fair trial, is it's about providing defendants with certain rights to make sure that the police actually got the right person, right, and that we are, in fact, producing reliable verdicts and we're realizing the truth. All right. So the first thing that happens when the police decide, all right, we've got this person, we're going to arrest them, we're going to charge them with selling drugs or robbing a bank or whatever, is usually if the police do not have an arrest warrant, and we'll talk about how that works in a second, but if the police do not have an arrest warrant, so the police are just sitting there on the street conducting surveillance, they see someone selling drugs, you don't need in the United States an arrest warrant to arrest someone when the police literally observe the crime in a public place. So they arrest that person. First thing you have is the filing of a complaint. The filing of the complaint has to be based on probable cause. So whenever police arrest someone and charge them with a crime, no matter what it is, arrest warrant or filing a complaint or otherwise, the police have to have probable cause that they've committed the crime. So essentially something a little bit less than a 51% chance, right, that this person has actually committed the crime that they're going to charge them with. So they have their probable cause and they file this complaint, and the complaint is just a very brief statement, very brief conclusory statement, right, that says this is what this person is supposed to have done. So here's a sample of a complaint, right, where the person has been charged with conspiracy to commit wire fraud, right, which doesn't sound good, right? So that's the very, just a basic criminal complaint that we have, first stage of the process. All right. Assuming that the defendant is arrested without a warrant, you have the filing of the criminal complaint, and then the defendant is brought before what we call a neutral and detached magistrate for something called a probable cause hearing. It's sometimes referred to as a Gerstein hearing, named after the case Gerstein versus Pugh, where the United States Supreme Court said that this was a requirement, right, of the Fourth Amendment. So before you detain someone for a prolonged period of time, the probable cause determination can't be made by the police officer on the street. Police are engaged in what the court says is the competitive enterprise of ferreting out crime. To make sure there really was probable cause, they wanted to actually have this determination made by a judge. It is a very brief hearing. The defendant does not present with a lawyer. The court makes a decision about whether or not there's probable cause on the basis of the criminal complaint that's submitted to the court and any other evidence the court might happen to have in front of it. And really, the Gerstein hearing is conducted to determine whether or not there's probable cause to believe the person committed a crime. And if there is, the person can then be detained. And we'll talk about the detention process after this. But then the person can be detained and have bail set and can stay in jail. However, if the court determines that there's not enough probable cause to believe this person committed a crime, the defendant's released. However, the charges can still be brought, and they can still end up going to trial. They just can't end up being detained in jail prior to trial. The reason is that in order to bring a case in the American system of criminal justice, unless we're talking about a felony at the federal level, which we'll talk about, all that you need to move forward is a prosecutor to say, I believe there's probable cause to charge this person with a crime. And so long as a prosecutor says that and swears out something like that, the complaint, the case can move forward. But if there's no arrest warrant that's been issued and the judge doesn't think there's probable cause to go forward, the case can still go forward, but the defendant just can't be detained. Anybody have any questions? All right. Assuming that the defendant can be detained, the judge says, well, I think there's probable cause, which oftentimes the judge says. You then have a bail hearing. And the bail hearing and the probable cause hearing they can happen at separate times, but most jurisdictions happen at the exact same time. And the judge then decides, okay, we're gonna talk about how much bail to put on this person, which is essentially the amount of money we want to put on the person to ensure that they come to trial, right? That they'll show up at court, right? Essentially the amount of bail that this person would never want to lose, so they'll always continue to show up at the trial rather than risk losing the money. And there's different kinds of bail that judges can put on someone. So sometimes the judge can say, okay, I don't think we need any money at all. I think there's probable cause. We could detain you, but I think you'll always come to court. This is fairly minor. So sometimes we'll call that ROR, or release on your own recognizance. Sometimes what the judge will do is they'll say, we're going to release you, but we can't totally trust that you're ever going to show up. So they'll put a house arrest or some sort of monitoring device on somebody. Sometimes the judge will say, okay, you have to promise that you'll show up, but if you don't owe any money now, but if you don't show up, you're going to owe $10,000, right? Sometimes we'll call that sign your own bail, and so the person will have bail in that sense. Or sometimes the judge will say, you know what, I don't think this person's going to show up at all, so person's going to have to have lost a lot of money before they would decide that it's worth it for them to show up in court, so I'm going to put $500,000 on bail on somebody or something like that, right? You don't usually see that, but it can happen. In certain instances, defendants can be detained without bail. If there's certain, in death penalty cases, defendants can be detained without bail. And if there's a showing that the defendant is particularly likely to flee the jurisdiction, right? Or the defendant is likely to destroy evidence or intimidate witnesses, and in certain types of other situations where a defendant may be charged with certain types of serious offenses and has, in addition to that, certain types of prior convictions. So if you fall into those types of categories, the Supreme Court has said it's constitutional to detain someone without bail. Otherwise, bail is regulated by the Eighth Amendment, and the Eighth Amendment has an excessive bail clause, and it just says if you're going to end up having bail that is given to a defendant, it can't be excessive. So, if I think that, Dr. Cusack has been charged with a crime, but it's fairly minor, and I think she's likely to come to court, it would be excessive to say you have to post, $1 million bail before you come to court. That would violate the excessive bail clause of the Eighth Amendment. But again, there are certain circumstances you can fall into where you can be held without bail. Otherwise, the bail requirement, the bail that the defendant has to pay, just can't be excessive under the Eighth Amendment. You do not have the right to an attorney at a probable cause hearing. Defendants have the right to an attorney at any critical stage in the process, but it does not appear as though And people can attempt to argue this going forward, and this may be a fruitful area of litigation in the future, but as of now, it does not look like that probable cause hearing is considered a critical stage, nor does it look like the bail hearing that takes place at about the same time is a critical stage. So you have no right to an attorney at either of those stages. Now, there's plenty of argument to be made that it is a critical stage, particularly the bail hearing, because defendants who are out on bail seem to have lower conviction rates. There's some competing philosophies for that, but one reason is defendants who are out on bail are better able to defend themselves. So maybe it is a critical stage, but the Supreme Court has not said that. Remember, before a defendant's detained, they have to have essentially a probable cause hearing. We know what that looks like when you're not arrested with a warrant, right? That's the Gerstein hearing. But you can be arrested with an arrest warrant, or the grand jury can indict you before you end up before the police go and actually arrest you, right? So that grand jury that we talked about, which serves this important investigative function, where they can issue subpoenas and get evidence. The grand jury also serves a screening function, which is before a defendant is charged with a crime, the grand jury has to decide whether or not there's probable cause. Grand juries almost always decide that there's probable cause if the prosecutor wants them to. American grand juries are very, very effective at their investigative function. They're not particularly effective at their screening function. Some people may debate that, but I think that that's the general consensus. But either way, when the judge issues an arrest warrant or a grand jury has indicted a defendant, a probable cause determination has already been made. And so at that point, the defendant can just be arrested. They don't need to end up having an additional probable cause hearing by the magistrate. They don't need a Gerstein hearing. They'll just be arrested, brought before the magistrate, and there'll be a discussion about their bail. Questions? Anybody have any questions? Yes?
What's the most often type of bail used? Is it the money bail? And how often does it happen that a person is detained because he cannot pay his bail?
Yeah, so monetary bail is the most often type of bail, and it happens quite frequently that people cannot end up paying that bail amount, and they end up being, in essence, sort of detained for their poverty level. So that's become a hugely controversial issue in the United States, particularly in light of the fact that there's a number of different studies that show that people, as I mentioned, who are out on bail are better able to defend themselves. Another thing you're likely to see is that people who are detained on bail are most likely to take plea bargains because they're more likely to be able to get out of jail earlier for agreeing to plead guilty. They're going to have to wait longer for a trial. And so that may result in a higher conviction rate for people who are in custody, not because many of those people might be guilty, but some people might not be, and they're just taking the deal so they can end up getting out. And so it's cash bail or monetary bail has become hugely controversial because many people can't post it. The reason they can't post it is there's, of course, a correlation between people who are impoverished and the level of crime that people commit. And so many people who are in American prisons are there because of economic reasons. And so there are many discussions in the United States about reforming how we set bail on people and looking at different and alternative types of bail to monetary bail that may be set. So whether it's more home monitoring or the idea that there's certain segments of the population who could be released and maybe without monetary bail, and maybe we're not doing a very good job of identifying them. Bail reform is a huge issue in the United States because it's very difficult for many people to post bail, and we do think that increases the likelihood of conviction. Where if you were at an opportunity to be out of custody, you might not take a plea deal, you may be better able to defend yourself. That answered your question. Anyone else? Any other questions? Yes?
What exactly is grand jury? What does it consist of?
Yeah, it's a great question, right? So grand jury is essentially comprised of citizens within the community. Different jurisdictions have different ways of creating a grand jury, but oftentimes a grand jury will be comprised of just a list of names of people who have decided that they're going to vote The United States voting is not mandatory, so people register to vote. So sometimes it will be comprised of a list of names of registered voters. Sometimes it will be comprised of a list of names of people who have driver's licenses in the community. So they'll sort of tap into, those are just two examples, but they'll tap into all different public sources of information. And then people will essentially be brought down for grand jury duty. And they'll actually receive a notice, right, that they by law have to report, and then they'll show up, and then they'll go through a process of selecting people on the grand jury. Oftentimes a grand jury will meet for an extended period of time, and so certain people won't be able to do it, and certain people will, and then they'll be seated on the grand jury. We'll talk a little bit more about how the grand jury works in just a moment, but the grand jury is, again, it's the United States is one of the few places in the Western world that even has a grand jury system. It was borrowed from the British. What had essentially happened is that, in a grand jury, the prosecutor presents evidence to the grand jurors, right? The defendant's not there, the defendant's lawyer's not there. This is how the federal grand jury works. States have their own grand juries. They can operate differently, but this is the federal system. Defendant's not there, the defendant's lawyer's not there. There are very few rules that constrain what a prosecutor can do in front of a grand jury. They don't have to, there are no rules of evidence. They can present evidence that has been illegally seized. They don't have to present evidence of the defendant's innocent. There's no one there to make counter arguments. That's why they seem to be very effective in returning these indictments. But the grand jury decides this person should be indicted, and then they make that determination. It's probable cause, and they indict the defendant. The framers of the Constitution really liked the grand jury system because it turned out that in the colonial times, the British would occasionally, I guess they would try and indict a colonist for something, right? And the colonists would resist the indictment because they didn't like the British crown. And so at the time that the American Constitution was created, the framers really liked the grand jury because it did serve a screening function when it came to telling the King of England that they didn't want to, go along with what the king wanted to do. However, because of all those rules I talked about, or the lack of rules, right, the fact that there's no defendant, there's no defense attorney, there's nothing that really constrains what the prosecutor can do, or very little in front of the grand jury, they return a lot of indictments. So it's not clear that in the modern era of American jurisprudence, the grand jury really serves the screening function in terms of getting weak cases out of the system that the framers had intended it to. So the question is, why does it exist? Right? Doesn't exist in most of the rest of the world. The British got rid of it in the 1800s. Why does it exist? Because the grand jury can, in addition to deciding who to indict, it can issue subpoenas, just like we had talked about. And in issuing subpoenas, it is a very powerful investigative function. So if I'm an American police officer and I want your business records, and I call you up and I say, why don't you show me your business records, show me your tax returns, right? You can just say, no, I'm not going to do that, right? And I only have two ways of getting it, right? I can go to the court and try and get a warrant, but I need probable cause. Or if I'm the prosecutor, I can convene a grand jury, convince these grand jurors that they should issue a subpoena, which can be based on a much lower standard, and then I can get the evidence. So the only reason it continues to exist is because it's very effective at investigating crime, not really screening out weak cases. Sure. All right. So at this point, right, you've been arrested, there's probable cause determination that's been made by the police officer, you've had your probable cause hearing, they've decided to detain you or release you one way or the other, right? You're moving forward. The next step 5 in the American criminal justice system is there are information jurisdictions and grand jury jurisdictions. So for most misdemeanor prosecutions, misdemeanors in the United States are usually a year or less. In terms of the potential sentence that you're looking at. Felonies are a year or more. Many jurisdictions in the United States with misdemeanors, once you're arrested, they can just bring you right to trial. There's not really much more screening that goes on. Felonies tend to be treated a little bit differently. And again, like I said, all you need to go to trial is the prosecutor to say, I think there's probable cause, so that's perfectly acceptable. In information jurisdictions, what happens is after you're arrested, you've had your bail set, you go to a preliminary hearing. Now, the preliminary hearing is, in essence, another probable cause hearing, right? It's another chance for the court to screen out weak cases. But a preliminary hearing differs dramatically from a Gerstein hearing. At that Gerstein hearing, remember, the defendant is there, but the defendant has no right to an attorney. The judge just makes the determination based on the information presented to them by the prosecutor. A preliminary hearing, I guess you could describe it as a mini trial, right? It doesn't have all of the procedural protections of a trial, but it's adversarial in nature. And the defendant does have a right to an attorney at that point, right? And the prosecution calls witnesses, and the defendant can call witnesses, there's cross-examination, the presentation of evidence, there's argument. And in this sort of adversarial process, the court is able to make a better determination theoretically about whether or not probable cause exists than when the judge at the Gerstein hearing is making that determination, or the grand jury, right, which is not particularly effective at screening out weak cases, is making that determination. The judge doesn't believe probable cause exists, they throw the case out, right? Case is over. If the judge does believe that probable cause exists, what will happen is that initial complaint, which had basically very little in it, it'll be converted to an information, which oftentimes doesn't have much more, and then the defendant will be brought to trial. So this is a brief transcript of what a preliminary hearing looks like. So in this case, I think the defendant was charged with stealing a car, and you can see what happens is the prosecutor has to call the police officer, right? It's the arresting police officer. This isn't a trial, this is just a preliminary hearing, right? And so we go on, right? The police officer identifies the defendant at the scene of the crime, and she says, "Officer, how did you come into contact with the defendant? On that date, I was patrolling in the area of 100 West Dauphin. I was approached by several people on the street saying that there had been an accident and that the person that was involved in the accident attempted to leave the scene." "Okay, did you go to the scene of the accident?" "I did. And what happened when you got there?" "When I approached the scene of the accident, I observed the defendant against a wall being held by several other people." "Did you see the vehicle?" "Yes." "Was there damage?" "Yes." "Did you approach the defendant?" "I did." He approaches the defendant. He's highly intoxicated, bloodshot eyes, slurred speech. "Did you talk to the defendant?" "I did." "Did he say anything to you?" And then I think what ends up happening at some point in all this, I may have cut this off, but as the police officer runs the car's information through this system that they have and realizes the car that the defendant was supposed to have been drunk while driving and crashed is stolen, right? So then they present their evidence. The judge is making probable cause determination. Is there probable cause to believe he's driving a stolen car? Turn it over to the defense attorney. Now the defense attorney gets to do a little bit of cross-examination. "And didn't you see you driving?" "No, I did not." "All right. When you got to the scene, was he already outside the car?" "He was," right? The defense attorney is about to try and argue to the judge that you don't know that this was the guy in the car, right? When you got there, he wasn't even in the car. "And you said people were holding him?" "They were holding him against the wall. Must have been 4 or 5 people there." "Was my client ever taken to the hospital?" Then the prosecutor objects, right? But, prosecutor objects, relevance, right? So the court says overrule. Lots of times the court just sustains these objections because they want to get out, they want to go home, but the judge will say, "Okay, you can answer the question." So the judge says overruled, right? So they answer the question. "No, he wasn't." "Were there other cars damaged as a result?" "Yes." "Did anyone do a blood test or breathalyzer?" "Not to my knowledge, I don't know." "So when you ran the tags to determine the car was in stolen status, did you learn any information about when the car had been reported stolen?" "Yes. I ran the tag just to make sure what I had and whose vehicle it was, and it was insured, not insured but registered. At that time, that's when the vehicle came in. Back in stolen status, the vehicle had been reported stolen within 24 hours." Right? All right. All of a sudden, the defense attorney rests. She's done. Right? She's not going to ask any more questions. The court says, "Okay," at which time there's argument. Now, there's a stenographer in the room typing all of this down, but the stenographer doesn't want to be bothered typing anything down anymore, so she stops, right? And then what the judge says is, "Okay, I think, given the totality of the facts, you have an accident and people are holding him on the scene. He's got the car keys, and he knows the car is not his, and it's stolen within 24 hours. I know it's all enough at a preliminary hearing level, which is just probable cause, right? This is not proof beyond a reasonable doubt. It's just probable cause. So I'm going to hold him over for trial." And then he ends up being held over for trial. And then the prosecutor at that point then files an information. All right. In many jurisdictions, you don't need a grand jury indictment. All you need is this information process. However, some jurisdictions use the grand jury process that we were describing before. On the federal level, if you're charged with a federal as opposed to a state crime, you always, the Fifth Amendment of the United States Constitution says that the prosecutor always needs to have a grand jury indictment. The indictment can be sought after the defendant's arrest, or as we talked about, even before it. We described this. The grand jury process is far less adversarial than the preliminary hearing process, and that's why many jurisdictions have decided to go with the information preliminary hearing process as opposed to the grand jury, because they feel like it gives them a better ability to screen out cases than what you have in the grand jury process. And some jurisdictions have both, right? So some jurisdictions allow the prosecutor to choose, decide information preliminary hearing or decide to go grand jury. I think that the reason jurisdictions keep this grand jury process is not, as I said before, because they think it's an effective screening mechanism, but they keep a grand jury process around because they want to give the prosecutor this enhanced ability to investigate crime. All right, after that, you have an arraignment. The arraignment is very simple. The defendant's brought before a judge. The defendant is given a copy of the indictment, grand jury indictment, or the information. They ask how they plead. The defendant pleads not guilty. We move into the pretrial stage of the process. If the defendant pleads guilty, right, the case is over and we move forward to sentencing. The defendants have a right to an attorney and an arraignment. All right, let's assume here our defendant pleads not guilty. We go into our pretrial motions. Defendant has many different types of pretrial motions that they can file. Some of them are very technical and don't touch on constitutional issues. So, for example, a defendant can file a pretrial motion and can argue that I have a right to the copy of the preliminary hearing transcript citing a rule of criminal procedure, not the Constitution. However, defendant can bring many other types of motions that are based in the Constitution, and perhaps the most frequently brought motion is a motion to suppress evidence on the ground that it was seized illegally under the Constitution. And the defendant can bring all different types of motions in that regard. One of the most common is the suppression of physical evidence. The defendant can argue that that was seized in violation of my Fourth Amendment right? So the defendant can argue I was stopped without reasonable suspicion, I was searched without probable cause, or maybe you had probable cause but you needed a warrant, right? You can have a whole big fight about this. This is sort of like, if you look through American criminal procedure, it seems like, there's about 1 trillion cases where defendants have brought these types of motions and courts have issued opinions. This is very common. The defendant can also argue my statement should be thrown out because I wasn't Mirandized, or the identification that took place where the victim identified me, that should be thrown out because that violated my due process rights. So the suppression of some form of evidence the prosecution intends to introduce at trial is the most commonly brought type of pretrial motion. If the defendant is successful in arguing the pretrial motions, then the judge will suppress the evidence and then the trial will go forward without the evidence. Now, if you have a case, for example, I one time had a case where there was an allegation that my client had bit a police officer, right? And then the police officer showed up and asked my client what had happened. They didn't Mirandize the client, and the client apparently had said, according to police officers, I bit the police officer, right? So we brought a motion to suppress the statement on the grounds that it wasn't Mirandized. We won. The judge suppressed the statement, but they could still go forward to trial because, the statement could help them, but at the same time, they also had a police officer there as a witness who was going to say, he bit me, right? They didn't need my statement to necessarily win the case if somebody believed that. However, if you're attempting to charge someone with unlawful possession of a firearm and the judge thinks that the search that took place was unconstitutional, right, and the judge suppresses the gun, then the prosecution, right, they can't really go forward because you can't find someone guilty of illegal possession of a gun if the gun has been suppressed from evidence, right? You can't believe that the person possessed something they weren't supposed to possess beyond a reasonable doubt if the evidence can't be admitted into trial. In that instance, the prosecution has an opportunity to appeal the judge's decision, but those are two possibilities. All right. Now, at this point, we move forward to plea bargaining. So if the defendant brings their motion to suppress and they win, maybe there's no reason for them to take a plea, right? It looks like they're going to win the whole case. but maybe the defendant only wins part of their motion to suppress, and now the defendant has some leverage. They go into plea bargaining with the prosecutor saying, it's going to be harder for you to win, why don't you give me a good offer? Maybe the defendant loses, right? And the defendant now, at this point, has very little leverage and just figures, oh, I'm going to get a worse sentence if I go to trial and take up everybody's time, so I'll enter a plea right now. At the same time, defendants can plea bargain, as we had talked about, at any point in the process. They can plea bargain after they're arrested, before we even get to the pretrial stage. They can plea bargain after the pretrial stage, right before trial. And sometimes in certain types of big investigations, the defendant knows that they're about to be arrested, they know they're about to be indicted, and sometimes there's plea bargaining that takes place even before the grand jury returns the indictment. Important to recognize that, and we just talk about it briefly here, but in the United States, plea bargaining is essentially how almost every single case is resolved. You may think from American movies or television, right, there's all these trials and there's juries and it's all this big exciting thing, and sometimes that happens. But in federal criminal prosecutions, some statistics from 2012, 97% of all federal criminal cases resolve themselves by way of a guilty plea. And in state prosecutions, it's about 94% of all state prosecutions resolve themselves by way of a guilty plea. So this has led some scholars to say, look, plea bargaining is not a part of the American criminal justice system. It is the criminal justice system. So let's say you're in one of those, 3% or 6% of cases that actually go to trial. We're now at step 9. Obviously, the jury can find the defendant guilty, not guilty, or the jury can decide we can't make up our mind, in which case you have what's called a hung jury, and the defendant can be retried, usually a number of times before the judge will no longer allow it. If the defendant is found not guilty based on double jeopardy protections, the defendant can never be tried again for the same offense. Right? It's over for the defendant for all intents and purposes. If the defendant is convicted, the case will end up moving forward to sentencing. At trial, the defendant has a whole host of different constitutional rights. Right? You could go on for a month about the defendant's constitutional rights. I just chose to highlight a few of them here. So the defendant has a Sixth Amendment right whenever the defendant is looking at a sentence that would be more than 6 months. The defendant has a Sixth Amendment right to an impartial jury. So not only do you have a right to a jury trial, but that jury must be impartial. So there's a lot of cases in the United States where we fight about what an impartial jury means. Jurors are brought in, they're potential jurors, they're asked a whole bunch of questions. We attempt to decide whether or not those jurors can be fair, and then those jurors end up being seated, and the defense and prosecution both have an opportunity to ask questions and also have an opportunity to remove jurors who they don't think will be fair, right, or they otherwise don't want on the jury. They can always argue to the judge, you should dismiss this juror who's not fair, and the judge may do that. If not, you have an opportunity to remove a certain number of jurors that you don't want on that jury. You also have the right to waive a jury trial. For certain strategic reasons, defendants may want to be tried just sitting in front of a judge alone, call that a bench trial. But because the Constitution gives defendants a right to a jury trial, the Supreme Court has said it doesn't necessarily give defendants the right to not to have a jury trial. So in certain jurisdictions, the prosecution has to consent to that, right? Which I know in Poland, right, there's not a right to a jury trial. It's my understanding, which must seem sort of crazy that not only is there a right to a jury trial in the United States, but if you don't want to have a jury trial, you have to have everybody agree to that, right? In certain jurisdictions. But that is, not every place, but that is kind of the way things will work in the United States. Jurors generally, for felony cases, consist of 12 people, but they don't necessarily have to. Jurors have to consist of at least 6, but generally consist of 12. In certain misdemeanor cases, that's not uncommon for jurisdiction. Well, not most jurisdictions still have 12, but misdemeanor cases are the cases most likely to have fewer than 12, and you can have usually about 6 jurors on that jury. Usually jury verdicts have to be unanimous, so if the jury wants to find you guilty, that has to be unanimous. Not guilty, that has to be unanimous, right? That's why sometimes jurors can't end up making up their mind. But verdicts do not necessarily have to be unanimous. It's not clear exactly what percentage of a jury has to believe that you're guilty. We can peg that at roughly about 75%, but we don't really know for sure. We haven't really had cases that would test the outer limit of that. What we do know is that you need at least 6 jurors, right? At least 6 jurors to find you guilty. So if you only have, 5-person jury, you can have a 5-person jury, and you can't have only 5 people on a jury vote to convict you. So if you have a 7-person jury, you're not going to be found guilty if only 5 of them will vote to convict you. And the reason for that is the Supreme Court has looked at different studies that show a jury's ability to accurately predict whether a person is guilty or not guilty. And apparently when only 5 people are inclined to believe you're guilty, the rate of false negatives and false positives is just too high for the Supreme Court to think was constitutional. The Due Process Clause of the Fifth Amendment means that the prosecution has to prove every element of a crime beyond a reasonable doubt. That's the standard that's used in American courts. We already talked about the right to an attorney because it's considered a critical stage. The defendant has the right to present their own evidence, and the defendant also has a right to confront witnesses who are brought forward to the trial. And the defendant has a right against self-incrimination, so the prosecution can't force the defendant to take the stand and testify against themselves. Before we move on to the last 2 stages, any questions? Done so far? All right, so we'll move forward to sentencing. Essentially, at sentencing, the sentence is imposed by the judge who presided over the trial, assuming the defendant is found guilty. There are different legislative pronouncements about things judges should think about when structuring the sentences. So some jurisdictions say, in this jurisdiction, the purpose of receiving a sentence is to punish you. In other jurisdictions, they'll say, well, the purpose is to punish you, but we also want to think about how the sentence will allow the defendant to be successfully rehabilitated into the community. So different jurisdictions instruct judges to think about different things at the time that they sentence people. For the most part, judges have a tremendous amount of discretion in sentencing defendants. Obviously, they can't impose sentences that violate the Eighth Amendment's prohibition on cruel and unusual punishment, and many jurisdictions have a separate rule that requires that sentences be otherwise reasonable, but judges are generally given a lot of discretion. In the United States, this results in some problems because the same crime in one courtroom could result in a slap on the wrist, and the same crime in another courtroom could result in a 20-year sentence. And so one of the things that jurisdictions have done to address that is they've enacted sentencing guidelines, which are designed to impose uniformity in sentencing. And there's also particular issues that exist with respect to the potential for racial bias in sentencing. So sentencing guidelines are designed to address that as well. There's federal sentencing guidelines. There's also state sentencing guidelines. This is an example of what state sentencing guidelines look like. I don't know if there's anything like this in Europe or in Poland. Guideline calculations can be extremely complicated. This is Pennsylvania's version of it, which I think is actually pretty simple. So basically, it looks a lot more complicated than it is, but essentially what guidelines do is they give a certain score to the seriousness of the offense that you've committed, right? So the legislature or a sentencing commission appointed by the legislature will decide this is really serious, this is not so serious. So something like, as you can see, what Pennsylvania said is most misdemeanors we don't think are that serious, so it's going to get like a level 1, right? Not that big a deal, right? At the same time, third-degree murder gets a 13, right? Really bad, right? And then what you do is you go across the other side and they compute a score based on the defendant's prior criminal record. If you have no prior criminal record, you're considered a 0, right? And then you can get to a point in here where your criminal record has so many points because each criminal record is a certain numeric value. At a certain point in Pennsylvania, they just stop counting how many convictions you have, right? And you fall into these different categories called refill or revoc. And what you do at that point is you just match up the offense gravity score, which is these numbers on, I guess it would be your left side of the screen, with the severity of the defendant's prior record, the prior record score, which runs along the top. And in that box, you see a suggested sentencing range in months that the judge is supposed to give the defendant. And that's designed to eliminate some of the discretion. Sentencing guidelines are generally guidelines, they're not commands. So judges don't necessarily have to impose the exact sentence that they see up there, but defendant can always appeal, and the prosecution can always appeal. If the prosecution appeals a sentence, that's not a violation of the defendant's double jeopardy rights. And what courts will say is that sentence is presumptively, as long as it's a guideline sentence, it's presumptively reasonable. So judges are, in most places that use sentencing guidelines, reluctant to deviate from the guideline range because, they don't want to get reversed on appeal. Defendants also have a right against self-incrimination in sentencing. So, for example, the federal guidelines, which are a little bit more calculated, you'll receive a certain sentence based on the amount of drugs that you sold, right? And that may not be established by the government during the trial. And so there's a case where the judge kept saying to the defendant, tell me how much drugs you sold, tell me how much drugs you sold, right? And if the defendant answered that question, it was going to increase their guideline range. They're going to look at a greater sentence, and they refused to answer that question. And the judge punished them for that, increased their sentence. And the United States Supreme Court came back and said, your right against self-incrimination applies in sentencing too. So if the judge starts asking you questions that they're going to use to harm you in sentencing, you don't have to answer them, and that can't be held against you. You have a right to not just a lawyer at sentencing, but an effective lawyer. And in the United States, you not just have a right to a lawyer, somebody who stands next to you and breathes. Whenever you have a right to a lawyer, you have a right to a lawyer who, from a constitutional perspective, is minimally effective. And it's a very complicated kind of area of law. And last thing I'll say is if there is any kind of sentence that the defendant is looking at that is mandatory, in the United States we love mandatory minimum sentences, or there's a sentence that if there's certain factors would increase the statutory maximum. So if the legislature says this kind of robbery, you get 10 years, but this kind of robbery committed for the purpose of racial intimidation, now you can get 20 years. Any factor that where there's a mandatory minimum or increases the statutory maximum, the judge can't decide that at sentencing. It's got to be presented to the jury and found beyond a reasonable doubt. It's considered to be an element of the crime itself. Post-conviction relief, do this quickly. In the United States, after you get convicted, there are two types of appeals. There's direct appeals and collateral attacks. Collateral attacks are very confusing, but direct appeals, there's no constitutional right to a direct appeal, but every jurisdiction in the country has created one. What happens on direct appeal is the defendant ends up bringing their case before an appellate court. Most jurisdictions have a two-tiered appellate court system. Not everyone. Anyone who's from Montana, you're from Montana, and hello out there. Right? Montana does not have an intermediate appellate system. It just has trial courts and then a final Supreme Court. But most have the trial court, and then there's an appellate court that hears the appeal, and then there's a state court of last resort. Federal government works like that. There's a trial court, and there's a circuit court, which is the federal court of appeal. Federal courts of appeals. There's many different circuits that hear cases, and then there's the United States Supreme Court. And usually what you can do is you can bring a direct appeal and allege any errors of law that the trial judge may have committed. Usually when you bring the direct appeal, you're almost always constrained by things that showed up on the record. So the appellate court has to be able to look at the record that was produced and adjudicate the claim. So you can always claim that there is an error in what the judge did, so long as that's on the record that's produced below. You have a right to, so long as a jurisdiction gives you an appellate right, and every jurisdiction does, you have a right to an attorney on your first appeal as a matter of right. So usually what happens is that first appeal you can take just because you want it, right? You have an absolute right to ask the appellate court to review what happened below. Then you can ask the last court, the state court of last resort, or the United States Supreme Court, to review the case also, but they don't have to. That's called discretionary. So you have a right to an attorney on your first appeal as a matter of right. Constitutionally, you do not have a right to an attorney on a second discretionary appeal. And then there's collateral attacks. I'm going to make this very quick because this gets very complicated. But let's say you go through the direct appeal process and you lose, right? So I'm convicted in the Eastern District of Pennsylvania. It's a federal case, Eastern District of Pennsylvania. I appeal to the circuit court. I lose at the circuit court. I then ask the United States Supreme Court to take my case. The United States Supreme Court won't take my case. I can then use a different statute that's been enacted where I can then challenge my federal conviction by asking a district court to review that conviction again. But usually the issues that I'm asking be reviewed are things not capable of being resolved on direct appeal. So they're things that wouldn't show up in the record. So for example, let's say I claim, my lawyer told me before I pled guilty that I wouldn't be deported. Right? That's not on the record. Right? What the lawyer told the client isn't on the transcript that's produced in court necessarily. So as a result of that, that kind of issue is the thing that gets resolved in a collateral attack, because the court's not making a decision based on the transcript. The court has to conduct a whole other hearing and then end up making a decision based on that hearing. And states have a similar version of how collateral attacks work. And in fact, you can really stretch out the appellate process by being convicted in a state court, exhausting your state direct appeals, then having a state collateral attack, and then losing your state collateral attack, and then trying to go to federal court to then have a federal collateral attack, which can go on for a very, very long time and is subject to very complicated set of rules for what types of cases can be brought into federal court on habeas cases from state court, and in what timeline. But usually it requires that the conviction was obtained in violation of the Constitution or in violation of federal law. And that's a very cursory explanation of it. I can assure you it gets far more complicated than that. Involved in unreasonable application of clearly established federal law as determined by the Supreme Court, or based on an unreasonable determination of facts as presented in the state proceedings. So there's a ton of cases where defendants are lost on direct appeal, lost in a state collateral attack, went to federal court, and then the federal court said, we can't even hear this claim because it doesn't meet that standard that I just read. And then a bunch of people appeal that, right, and go on and on and on. But that's sort of how the appellate process works. Most defendants are unable to meet the standard, like I said, and it can ultimately go up to the Supreme Court. So I know that is a very sort of quick thumbnail sketch of the American criminal procedure, and some of it may get a little bit confusing, but or involved. But I wanted to ask if anybody had any questions. Yeah, sure.
I'd like to go back to the pleading stage. If you've heard about phrase meet them, plead them. What do you make of it?
Yeah, so I think that it's a very sort of common critique of the American system of criminal justice, right? And it relates in a lot of ways to, I think, our right to counsel. So in the United States, you have the right to have an attorney appointed for you if you can't afford one. In any felony case and in misdemeanor cases, you have a right to an attorney if you're going to go to jail under the federal Constitution, but most states provide you with a right to an attorney in a misdemeanor conviction. So, and of course you have the right to hire your own attorney if you can afford one, but in essence, this idea that the state has to appoint an attorney for you, while we think of that as this important aspect of American criminal procedure, it's kind of egalitarian in scope in a sense, right? It's that it doesn't matter if you're rich or you're poor, everyone in America has a right to a lawyer and a right to sort of hold the government to its burden, and there's something about that we feel good about as Americans. The reality of it is that that system is massively underfunded. While the states, particularly in felony cases and in certain misdemeanor cases, have to provide lawyers, because the United States Supreme Court said so, they receive no money to do that, and so the states have to pay for it themselves. And so oftentimes I think that meet them and plead them expression comes about because you have lawyers who, despite their best efforts, receive these cases, right, and they're just overwhelmed. And so they don't really have the ability to necessarily investigate every case or put the time into every case that they would like to. And so unfortunately being overwhelmed creates an incentive to end up seeing a lot of plea bargaining. And I think that's kind of what that meet them, plead them expression relates to. There are other reasons people plea bargain. So for example, in the federal system, oftentimes Congress has enacted laws where the sentence is even greater than what Congress thinks the person really deserves for this particular offense. But the idea behind it is you don't want to go to trial, right? You don't want to take up people's time. You don't want to take up people's resources. You can have the best attorney in the world, right? But the attorney might still be, you might still roll the dice. And so people will plead just to avoid this horrific sentence. So that's another reason that you have plea bargaining, because there's such a significant tax for going to trial. But your critique, or the meet the plead them critique, I think that relates most heavily to how overwhelmed people providing legal services to poor people are. It's a long-standing criticism of the American criminal justice system, and it's something people have called on to reform, increase the amount of funding that goes into indigent defense services. There seems to be more movement in that direction, but it's still very much a problem, right, and a significant issue in the United States. Plea bargaining, I don't think, is at least we here in the United States, one of the critiques of the plea bargaining system is that it's more prevalent in the United States than it is elsewhere in the world. And this is one of the, I think, one of the criticisms of our system. Yeah.
Those who accept that plea still have the right to an appeal and to a trial if they wish.
So it's a great question. So you have no right to a trial, right? So you plead guilty, it's over. You do have the right to appeal, and you can appeal on certain grounds. So you can appeal if you were to suggest that your plea was not knowing, intelligent, or voluntary. So constitutionally, every plea has to be knowing, intelligent, and voluntary. And there's a series of things that go into that, such as things that the judge has to tell you, such as the maximum sentence you're looking at, and certain constitutional rights that you're giving up. So you can plea on that basis. You can claim that the sentence you received was illegal. You can never receive an illegal sentence, so you can claim that. In that sense, you're not trying to disturb the conviction. You would just be trying to receive a legal sentence. You can claim, for whatever reason, that the court had no jurisdiction to accept the plea. Right? A plea is a nullity if a court couldn't have entertained it to begin with. And you can also plea and claim that you have a right to a lawyer when you plea, but not only do you have a right to a lawyer, you have a right to an effective lawyer. And you can say that in giving you advice that caused you to plead guilty, your lawyer was otherwise ineffective. So those are sort of four common bases on which you can appeal a guilty plea. Of course, defendants are free to argue any other basis, right, that they possibly can. There are appeals following guilty pleas, but obviously far fewer than appeals following convictions after trials. But you can't have a trial. You plead guilty, that's over. Unless you win your appeal on the plea, right, the plea's vacated and you return to sort of the position you were in before, then maybe you can go to trial, but your appellate rights are somewhat limited. Anything else? Okay, so if there's nothing else, oh, sure. No?
How much in your opinion mandatory minimum sentencing infringes on the court's discretion to sentence?
Yeah, there are a tremendous amount. So there tend to be a lot of mandatory minimum sentences in the United States, particularly for drug offenses. And one of the things that you have seen happen is traditionally in the United States, the legislature set parameters, right? So the legislature might say, okay, this crime you can get up to 20 years. And the judge then had sort of broad discretion to weigh the facts before them as they were presented in the case, and also to take into account who the defendant was when fashioning the sentence. And that was problematic, because it created a circumstance where you had very disparate sentences between judges, or you had an unreasonable judge, and that's why those guidelines existed. But one of kind of the hallmarks of sentencing was that judges had discretion to evaluate the facts and look at who the defendant was. Mandatory minimums take that away from the judge. What it really does is it does two things. So number one, it shifts the sentencing component of the criminal trial more towards the power of the legislature than it does towards the judge's discretion. The legislature always had power to decide what the broad range was or to create guidelines, but in this instance, the legislature is saying the judge's discretion doesn't so much matter. If the judge thinks you don't deserve the mandatory minimum, it doesn't matter. So the legislature has used mandatory minimums to exert more control over the sentencing process than they had previously had before the invention of mandatory minimum sentences. That's not necessarily a positive thing, because we may want judges to be able to take account of all of the facts and the specifics of the defendant. The other thing it's done is it's shifted a lot more power to the prosecutors. So one thing that prosecutors can do is let's say there's a certain crime that carries with it a mandatory minimum sentence. And then there's a certain crime that doesn't. One thing prosecutors can do is prosecutors can decide to charge you with the crime, right, that has the mandatory minimum sentence. If you don't plea bargain, right? And then if you will plea bargain, they'll charge you with the crime that might not, right? Yeah, so it's essentially it gives prosecutors a lot of coercive power in the plea bargaining process, a lot more power than they might have had before, right? Because now they have, you could have said before, well, I'll go to trial, I'll argue to the judge the sentence I really deserve, and I don't deserve that sentence, and maybe you thought that was a good case. But now that, right, you feel like, well, it doesn't matter, I'm going to get the mandatory minimum. If we go to trial and get found guilty, the prosecutor's a lot more ability through their charging preferences to be able to direct what happens in a case. And so I think mandatory minimums have been hugely controversial as well. We have had some positive movement in that direction, just in the sense that, let's say there's a mandatory minimum sentence that said you have to get a year in jail if you sell 2 grams of crack cocaine. Previously, before this case called Eileen, you would go to trial for selling drugs, you'd get found guilty, and then the judge would make that determination at sentencing, how much drugs you sold. And while the judge couldn't force you to give them that information, the judge only had to make a finding based on a preponderance of the evidence, which is a much lower standard than reasonable doubt. The United States Supreme Court has come in and said any factor that would lead to that mandatory minimum now no longer is up to the judge to make the finding based on this preponderance standard, but now you have to present that to the jury. So you have to convince the jury not just that this person sold drugs beyond a reasonable doubt, but this person sold 2 grams of crack cocaine beyond a reasonable doubt. And so that has been somewhat of a, I guess from the defense perspective, a positive shift in mandatory minimum sentences. It's now not nearly as easy for the judge to give them as it was before. Okay, well, thank you very much, everyone. I appreciate your time.